One of the eligible uses for the American Rescue Plan State and Local Recovery Fund is to provide premium pay for essential workers and critical infrastructure. Premium pay is defined by the U.S. Treasury as an amount up to $13 per hour in addition to wages otherwise received and in an amount not to exceed $25,000 per eligible worker. U.S. Treasury guidelines state that this premium pay can be applied retroactively to the beginning of the pandemic, which is March 1st, 2020. Article 7, Section 14 of the Louisiana Constitution, however, generally prohibits retroactive pay for public employees, so many public entities questioned whether they could provide retroactive premium pay for their eligible essential workers. The Attorney General issued an opinion stating that, yes, public entities may use American Rescue Plan fiscal recovery funds to provide retroactive premium pay to their eligible essential workers, but only if certain conditions are met. First, the entity must adhere to the U.S. Treasury Rules on providing premium pay. The U.S. Treasury Final Rule provides specific guidelines for recipients of these funds to identify, verify, and confirm employees who are eligible to receive premium pay. Recipients must consult U.S. Treasury guidelines to make this determination. The final rule can be found here. Second, the entity must make sure the payment of retroactive premium pay satisfies to the Cabelas Test. The Cabelas Test comes from the name of a case the Louisiana Supreme Court decided that established 3 factors to determine whether the use of public funds comports with the requirements of Article 7, Section 14 of the Louisiana Constitution. First, the expenditure must be for a public purpose that comports with the purpose the entity has legal authority to pursue. The Attorney General says public entities have the authority to pay their employees, so this part's met. Second, the expenditure taken as a whole does not appear to be gratuitous. The Attorney General says that by following the U.S. Treasury guidelines, the payment of premium pay cannot be gratuitous. U.S. Treasury guidelines ensure that premium pay goes to those lower to moderate income essential workers who have not yet been compensated for the heightened risk they face for essential work during the public health emergency. Third, the public entity must demonstrate that it has a reasonable expectation of receiving something real and substantial in exchange for the expenditure. The Attorney General says meeting this part of the Cabelas Test is fact-specific and will vary from entity to entity. However, the Attorney General adds that an entity can meet this part by ensuring the retroactive premium pay is tied to a quantifiable amount of essential work performed by the eligible worker during the public health emergency. That means entities should award retroactive premium pay based on hours actually worked by each worker, rather than awarding the same sum for all workers. Note: the analysis of the Attorney General in AG Opinion number 21-0107 applies only to the use of American Rescue Plan fiscal recovery funds to pay premium pay. Entities should not rely on this opinion for other uses of public funds. It is very important that entities that use American Rescue Plan fiscal recovery funds for premium pay to document their determinations to show how they met both the U.S. Treasury guidelines and the Cabelas Test. Learn more by visiting the legal FAQs at the Legislative Auditor's website at lla.la.gov. This video is for informational purposes only and is not a substitute for legal counsel. Please consult with your attorney before making any decisions.